Trying to figure out a labor dispute in the Philippines, it can honestly feel like you're trying to solve a puzzle in the dark. It's just so complex, super confusing, and yeah, really stressful for everybody. So today, we're going to flip the lights on. We're going to give you a map. So maybe you're an employee and you feel like you've been totally wronged, or you're an employer and you're just trying to do the right thing and follow the rules. Either way, the biggest question is always the same. Where do you even go? Who has the actual power to listen to your side and make a real decision? Well, that's exactly the problem we're going to tackle right now. All right, so here's our game plan, our map for today. We're going to start with a quick overview, then dive into the role of the DOL, that's the Department of Labor and Employment. After that, we'll talk about the labor arbiter, touch on how unions fit in, and then wrap up with how appeals work. I promise, by the end of this, the whole landscape is going to make a lot more sense. Okay, first up, the DOL. The easiest way to think about them, they're kind of like the Inspector General of the workplace. Their main job is to be the first line of defense, making sure companies are actually following the basic, non-negotiable labor standards. We're talking minimum wage, overtime pay, safe working conditions, all that fundamental stuff. So what's their big weapon here? It's something called visitorial and enforcement power. Now, that sounds super formal, but it's spelled out right there in the labor code. And what it means is they have the legal authority to literally walk into a workplace, check the records, and issue an order telling a company to get in line with the law. It's a really proactive, really powerful tool. Okay, but this is where it gets tricky, right? What happens if an employer just says, hey, wait a minute, that person, they're not my employee. So all those labor standards, they don't apply. Can the DOL inspector actually decide that right there on the spot? It's a huge question. And the answer is a resounding yes. Absolutely. The Supreme Court has been crystal clear on this. The DOL has to have the power to determine if an employer-employee relationship, what lawyers call EER, actually exists. And the logic is just plain common sense, right? If they couldn't make that call, any employer could just say, not my employee, and poof, the DOL's enforcement power would be completely toothless, useless. All right, so to make this super easy to remember, let's use a little acronym. Just think VEER. V is for their visitorial power, E is for their enforcement power, the second E is for their power to determine the existence of an EIR, and R, this one's important, so file it away for later, a reduction of the appeal bond is not allowed on appeal from a DOL order. We'll definitely circle back to that one. So that's the DOL. But what happens when things get more serious? I'm talking about disputes over termination or cases involving big money claims. Well, for those, we head to our next stop on the map, the labor arbiter. Think of the labor arbiter as the main courthouse for labor cases. Okay, for the labor arbiter, there's one golden rule you have to understand. It's called reasonable causal connection. This is the key that unlocks everything. To figure out if a case belongs with the labor arbiter or in a regular court, you just have to ask one simple question. Is this dispute directly linked to the employer-employee relationship? Did it happen because of the job? If the answer is yes, then bingo, it goes to the labor arbiter. And this table here, it lays it all out perfectly. Illegal dismissal? Well, that's the classic labor dispute, so that's a definite for the labor arbiter. What about a training bond that was breached? Since that bond only exists because of the employment contract, yep, that also goes to the labor arbiter. But here's the twist. What if you're suing for damages from an unsafe workplace? That often falls under negligence, or what's called a quasi-delict in the civil code, so it lands in a regular court. And a simple car loan from your boss? That has nothing to do with the work itself. It's just a civil debt, so regular court it is. So to keep it straight, here's another handy acronym. If your case looks like one of these, you're probably taking a trip to civil court. T is for tort, or harm from serious negligence. R is for reimbursement claims, say between a contractor and their main client. I is for simple indebtedness, like loans or mortgages. And P is for pre-employment breaches. This is key, where an employer-employee relationship never actually got started. All right, let's switch gears for a second, because not every dispute is just one employee versus the company. Sometimes the conflict is, well, it's internal. It's inside the workplace family, if you will. And this is especially true when you bring unions into the picture. When it comes to these internal disputes, you've got two main players. First, there's the Bureau of Labor Relations, or BLR. Just think of them as the union referee. They're the ones who handle fights between different unions or fights within a single union, like a messy leadership election. Then you have the voluntary arbitrator, or VA. Their role is to be the CBA interpreter. If there's a disagreement about what the collective bargaining agreement, the CBA, actually means or how to implement it, the VA is the one who makes the call. And here's something you absolutely have to know about voluntary arbitrators. Their decisions have real teeth. Why? Because their ruling is immediately executory. That means it has to be followed right away, even if someone is trying to appeal it. It's a huge deal and gives their decisions a ton of weight. Okay, so let's say a decision has been handed down by the labor arbiter. But what if you think they got it wrong? What if you want to fight it? Well, that brings us to the final leg of our journey, the appeals process, and how a decision finally becomes, well, final. So let's start with a little pop quiz. Imagine this. An employer loses a case. The labor arbiter orders them to pay a pretty big monetary award. Now, the employer wants to appeal to the next level, the National Labor Relations Commission, or NLRC. What is the single most important thing they have to do? The answer? The appeal bonds. And let me tell you, the law on this is ironclad. It is not flexible. The employer has to post a cash or surety bond that is equal to the full monetary award. This isn't just a simple rule. It's what we call jurisdictional. That means if you don't post that bond, the NLRC literally has no legal power to even look at your appeal. It's a non-starter. No bond, no appeal. End of story. So the obvious next question is, what if the award is massive? Can you ask for a break, a reduction in that bond? The answer is yes, but there's a very big catch. Thanks to a huge case called McBurney v. Ganzon, to even file a motion to reduce the bond, you first have to post a provisional bond of at least 10% of the total award. It's basically a way of showing good faith, proving you're serious while they consider your request. So after all the appeals are done and a decision becomes final and executory, a really powerful legal idea takes over. It's called the immutability of judgment. And this quote here just says it all. A decision that has acquired finality becomes immutable and unalterable. Basically, it's set in stone. You can't change it, you can't add to it. The Jordan case is a perfect example. You can't try to add back wages to a final decision that already said there was no illegal dismissal to begin with. The case is closed. However, like with any good rule, there's a big exception. And in this world, it's called the Knockar Doctrine. This is a super important one. The Knockar Doctrine did two main things. First, it said that for illegal dismissal cases, monetary awards like back wages have to be recomputed all the way up to the date the decision becomes final. And second, it standardized the legal interest rates on those awards. The Knockar Doctrine basically drew a line in the sand. For any monetary awards that became final before July 1, 2013, the interest rate is 12% per year. For anything that became final on or after that date, the rate drops to 6% per year. It seems like a small detail, but when you're calculating the final payout, it makes a huge difference. Okay, let's zoom out and look at the whole map we've just drawn. It's pretty clear now, right? You've got the dole. They're the inspector on the beat, checking for basic standards. You have the labor arbiter, that's the main courthouse for serious stuff like termination and money claims. The BLR and the VA, they're your internal referees for all things union and CBA related. And finally, the NLRC and the courts are the path of appeals, where things get a final review. Each piece has its own very specific job. Look, the labor justice system is definitely complex, no doubt about it. There are tons of details we didn't even get to. But honestly, the biggest hurdle is usually just not knowing where to begin. That confusion starts to melt away once you have a map. And now, you've got one. That's the most important first step in any legal journey. So the only real question left is, are you ready to find your way?